rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140079, R&J Recovery versus Wells Fargo Bank. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we have conferenced the case prior to argument. So, Mr. Ensign, you may proceed.
Good morning. I'm Curtis Ensign. Represent the plaintiff appellant R&J Recovery, LLC. As the court knows, the case before you today is between a depositor with a bank, Wells Fargo. The R&J Recovery prevailed with respect to an unauthorized withdrawal from its bank account. The court granted summary judgment to R&J but declined to award any fees. The trial court was requested to set forth why it was declining to award any fees, but it declined to do that. It is submitted that there is whether or not there's an agreement is no longer in dispute. There was a 3-count complaint. The motion for summary judgment was brought on count 1 of the complaint, which is the breach of contract. The court found there was a contract and a breach. That was the only count before the judge. And the judge, in his remarks, which we didn't have the transcript at the time the motion for fees was made, but he described it as a type of subcontract. But he clearly found there was a contract and a breach. That was the only way he could award summary judgment on count 1 of the complaint. However, when R&J made his motion for fees, that was the law of the case, that there was a contract, that it had been breached. That ruling has not been appealed. So that is, in fact, the law in this case, is that there was an agreement and that there was a breach of that agreement. Now, even Wells Fargo can't really deny that there was an agreement. They admitted in their brief that it's given to all business account holders. When asked by Judge Cunanan, are you denying that there was an agreement between the parties? They could not deny that. So this is just not an issue anymore, and it wasn't an issue when the motion for fees was made. Now, therefore, we submit that there was the power in the court to make an award of fees, but it declined to do so. Now, so we're saying there's an abuse of discretion here on the part of the trial judge in refusing to award attorney's fees. Now, this court, we know, will uphold it if there's any reasonable basis for the court's decision. But if you look at the factors, we submit each and every one of them supports Wells Fargo. There is no factor that supports Wells Fargo or a denial of fees.
Mr. Ensign,
yes.
Let's assume for the moment that you're correct, that all of the Warner factors tip or lean towards your client. But I think we have case law that says even in that situation, a fee award under 12-34101 is not mandatory. A judge still has discretion to decide not to award fees, even if all of the Warner factors go to the prevailing party's way. So how do we square your argument you've just made with that?
Because there's no, in the record, there is no reasonable basis for the denial of fees.
Well, but the court has discretion, and it may have decided, for example, that given the magnitude of what was at stake versus the amount of fees requested, that this case wasn't going to exercise its discretion to award fees. I mean, I think our case law is that a court, you're not entitled to a fee award under the statute. It is completely discretionary. And the court here exercised its discretion, and it's not required to award fees, even if the Warner factors go your way.
Your Honor, we submit there is nothing in the record that supports the trial court's exercise of its discretion in denying fees.
Well, go ahead, Darren.
Well, let me throw up, because again, our case law says that the trial court's not required to specify why it ruled the way it did. Yes, it would be helpful for our appellate purposes if it had, but isn't there some evidence in the record? First of all, we know the amount at issue and controversy, and then isn't there information in the record regarding settlement overtures that Wells Fargo made that could have caused the Superior Court to believe that this didn't need to be litigated?
No, there aren't. The record is clear that we tried 3 times to get any answer out of Wells Fargo before litigation. Stonewalled each and every time. We did not know the facts. We did not know how this withdrawal could have occurred. So we filed, after that, we filed with the comptroller of the currency. And they, in response, still didn't say what the facts were. They sent an anonymous response to the comptroller of the currency and said, we have determined this to be a dispute between owners of the company and should be handled as such. In other words, don't bother us.
No,
You
and I
guys
get
go
that,
litigate it.
But at some point, and I guess it would be helpful if you could tell me where this happened in the timeline of events, when Wells Fargo basically said, look, if you can't recover from the third party, then we'll cough up $17,000 at 1.16. When did that occur?
Immediately.
What do you mean immediately?
They made a motion to dismiss and said you have not been damaged after the complaint was filed. You've made a motion to dismiss. You have not been damaged. You have to pursue Mr. Pearson, who the money went to, and get a judgment against him. And then they offered and said, okay, you go to arbitration with Mr. Pearson. If you get a judgment against him and you try to collect it and you still can't do it, we'll pay you the principal amount of your claim. But if you lose, we're not paying you anything. Your complaint has to be dismissed with prejudice, which is not the law. If there's an unauthorized withdrawal, we don't have to prove that that person wasn't entitled to the money. This is a contract between the bank and the depositor.
But forgive me, but before RJ sued Wells Fargo, it had filed an arbitration proceeding against the third party who actually withdrew the money.
Yes, Pearson filed the arbitration
Well, that's
proceeding.
right, but
Yes.
nevertheless, excuse me, you're absolutely right, forgive me. So the arbitration was pending. And as between a wrongdoer, which is the third party here,
Yes.
and Wells Fargo, Wells Fargo is now, this has been determined, is liable on the merits. But between a wrongdoer and Wells Fargo, I can see that there is a rational reason for a trial judge to say, as between the two of them, the wrongdoer should be the first person you should look for payment versus Wells Fargo. And so their proposal that if you recover against the wrongdoer and cannot collect, and we then will stand up and stand good for the difference, or for the amounts you can't collect, that to me seems rather reasonable. And I can see the trial judge thinking the same thing.
Your Honor, it's an individual.
Right.
That offer was made after we sued them, after we tried to get a copy of the agreement, after we tried them to explain what happened. They wouldn't do anything, so we had to sue them. And then after we sued them, that's when they came up with this. But we would have had to spend, I don't know how many thousands of dollars chasing an individual who didn't have money, and then we have to prove to them that we couldn't collect from him. That's not the law.
Well, the issue here is the exercise by a trial court of its discretion, which is very broad, under 12-34101. And, the standard is there a reasonable ground in this record? And I'm suggesting to you that I personally would have made perhaps a different decision. But that's not, the law according to Norris is not the standard here.
Well, but if he's going to exercise discretion, there has to be some basis for that. And no one can point to anything in the record that indicates a basis for that discretion. And all of the factors that courts look at point in favor of R&J.
If you had, or your client had, we know from the record your client prevailed against the third party in the arbitration. We know that from the record.
Correct.
Okay. there's a general proposition barring double recoveries. So if your client prevailed against the third party and collected money, you couldn't collect that money from Wells Fargo. So their proposal had some logic to it, which is, you're not going to get a double recovery, go and see if you can get the money out of the wrongdoer. If you can't, and it's not collectible, then we'll stand good.
Your Honor, we submit that's not logical.
Why is that not logical?
Well, because they should have said, we made a mistake, here's your money back, our customer, our depositor, and we'll go get Mr. Pearson, who we wrongfully gave the money to. That would have been perhaps a reasonable proposal. But to say, you've got to chase Mr. Pearson, you've got to get a judgment, they're trying to say that they should have offsets that Mr. Pearson might have. They're saying, you got to go get a judgment. If you can't get a judgment, you haven't been damaged. And that, we spent tens of thousands of dollars getting a judgment against Mr. Pearson for a lot more than the 16.5, and it's not collected. But in point of fact,
that's not in our record, that it's not collected.
Okay, it's not in
So
the record.
we really
But you're
can't look at
saying
that.
about this proposal, and I'm trying to argue why it's not a reasonable proposal. And first of all, it was the principal amount of the claim. No fees, no costs, no interest, and spending tens of thousands of dollars to prove that, well, gee, Mr. Pearson doesn't have the money. All of because of the bank's error. This wasn't our error. This is something the bank did. And then they're saying to their depositor, well, yeah, it's our mistake and we shouldn't have done it, but you first have to jump through all these hoops. We submit that is not a reasonable proposal. And there are offers of settlement in the record. We offered to settle, we said, let the court decide attorney's fees. You know, give us the 16.5, judgment for the 16.5, let the court decide. We also offered to settle for a little bit of attorney's fees, less than what it had been occurred, and there was not one response to any of these offers, none.
Can you tell me when the first offer that you just mentioned, the 16.5 and let the fees abide a court ruling, when was that settlement offer made? Was it before the litigation was filed or after the complaint was filed?
We couldn't get anybody to talk to us before the complaint was filed. So there was no offer made. And we didn't even know how this had happened. No one said, oh, well, Pearson came down and signed a withdrawal authorization, so that's why we gave him the money.
I think, wasn't the letter from, well, there was a letter from Wells Fargo in March 2013. I think this is Exhibit 1 to Item 50 in the record.
I guess my point is, was that fairly early in the litigation? That was presumably after the motion to dismiss was denied, but before the summary judgment proceedings?
Is that our offer you're talking about,
Yeah,
John?
your offer.
I was trying to get that for you. We made, I think, 3 different ones.
Well, and we can look at the record.
And I'm sorry, I don't have it here handy for you.
Judge Norris kind of teed up the issue in that I personally wouldn't have issued this ruling either, but an abuse of discretion standard is very forgiving, and so therein lies the struggle. I understand the points you're making, but I
Okay.
also...
Well, we submit there's absolutely no reasonable basis for the trial court's ruling. If you look at the factors, they're all in our favor, and I would like to reserve 5 minutes here. We submit that the court should award attorney's fees that were incurred in the trial court, in this court, because there was no serious objection to that. They didn't object to any particular item. And I have a backup argument on the motion for new trial, which I don't have time to go into right now. But if the court was not inclined to grant any other relief, there was gamesmanship on trying to get this agreement even after the motion was decided. And we had to compel discovery, and then they say they voluntarily produced the agreement. Unfortunately, it's worked so far for them, because when the judge made his ruling, we had not had a chance to give him the depositor agreement to prove clearly that there was, in fact, a written agreement involving these parties. And we submit that if there's no other relief, then you ought to at least grant our motion for new trial and reverse the trial court on that and let the trial court decide it in view of the fact that there's an agreement, and it's there now. And I think the briefs detail the efforts we went through to try to get the agreement, and they just wouldn't give it to us, saying, well, you can't do that, there's been judgment entered, can't do discovery. And we, I think, quite clearly indicated, yes, we can get it, yes, you have a duty to disclose, and they finally gave it, but after I filed a motion to compel. We submit that there is no reasonable basis in the record here to support the discretion of the judge, and this is just a ruling that has no, from R&J's standpoint, no basis to support it. Look at the factors. That's what courts are supposed to look at. And yes, there's no presumption of an award of fees, but if every factor is in your favor, we submit there should be an award of fees. And unless there's some other factor that is a reasonable basis for the denial of fees when you have all these factors in your favor, then this court should reverse the trial court and say, yes, you were entitled to an award of fees. There is no logical basis for the trial court's decision denying fees, and that they should be awarded. Thank you.
Thank you. Mr. Silence.
Good morning, Your Honors. Jeff Silence on behalf of Defendant Appellee, Wells Fargo. Your Honors, the trial court heard all the arguments that appellant now makes, heard all the evidence, gave the parties an opportunity for an oral argument just like this one, and after weighing the evidence, hearing the arguments, it decided not to award fees.
Why?
Appellant has, the answer is I don't know. We could speculate as to why.
Doesn't there need to be something in the record showing that the court actually engaged in a discretionary decision?
Yeah.
What we have before us, sometimes a court will say, I've considered the Warner factors and I deny, and that gets us a little bit down the road, but don't we have to be able to have some confidence that the court actually exercised its discretion?
Yeah, there's several reasons why I think the trial court denied fees. My answer to your question was I don't know what the trial court's, what's in its mind.
You don't know, and we don't know.
Exactly.
And there seems to be, I will tell you, when we have a situation like this where there's, and I don't mean any pun on your last name, radial silence from the trial court, and this is really a situation like that, it is very difficult for us to do our job, and it strikes me that it is close to. I'm not sure I'm there with an abuse of discretion yet, but I find this case really troublesome because it makes us come up with reasons to justify what the trial court did. And there may well be some justifications in this record. I'm not necessarily saying there aren't, but it makes our job really difficult. And I'm not sure that is, from a jurisprudential standpoint, appropriate for our system and how it works. I mean, it causes me real concerns.
I think that of the 6 Warner factors, 3 favor Wells Fargo. And the first one would be the merits of the defense. Although Wells Fargo lost, it raised several defenses. The first was that he didn't prove there was a contract. He didn't attach a copy of the depositor's agreement to the...
I will tell you on that, we have case law that says as a matter of law, the relationship between a bank and a depositor is held to be that of a debtor to a creditor and arises out of contract. We have law that says that they alleged in the complaint that there was this banking relationship, and I think they alleged a contract. Wells Fargo didn't come up with any evidence that didn't exist. So, sir, that's not a persuasive argument. When we have law in this state that, since 1942 no less, that holds that.
I don't dispute that that's the law. What I dispute is that he didn't make that argument in his complaint or in his motion for summary judgment. The first time that argument appeared was in his reply in support of his fee application.
Well, one would think it is so obvious you don't need to. The phrase teach your grandmother how to suck eggs comes to mind, but really.
Well, one reason it's important is because had he attached a copy of the depositor's agreement to the motion for summary judgment, as you'll see, there's language in the depositor's agreement that says if Wells Fargo, in good faith, gives out money to an unauthorized person and they, based on a mistaken belief of actual or apparent authority, that's not a breach of contract, or at least not a breach of the depositor's agreement. Now, there may be ways around that, bringing a negligence claim, or the court might say that's not enforceable. But there is language based on the plain language of the policy that says what Wells Fargo didn't breach the terms of the policy agreement.
Okay, let's say we don't think that was a very good defense. What have you got next?
Yeah.
Okay.
Under the Warner factors, what you
Right.
said there are three.
And
What
the
are
other one
two?
is settlement efforts. Wells Fargo did offer to pay the full amount of money. And in response to your questions, I believe Wells Fargo made a oral offer to do this before litigation ensued, that they'll pay the full amount. But the first written offer that I'm aware of, offering to pay the full amount of the principal, came after litigation ensued. I wasn't involved in the trial, just the appeal, but that's my understanding from reading the record.
And on its face, that has some appeal, but what about Mr. Ensign's argument that, well, that was only to repay the principal. We had to track down this judgment-proof person, initiate proceedings, incur costs and expenses, and so that really wasn't, under the circumstances, a reasonable offer.
Well, as in all settlement offers, you don't always get everything you want, and offering to pay the full principal to someone is everything he wants. He just wasn't happy with the conditions that he had to satisfy first in order to get that. But Wells Fargo's position is that it had viable defenses that it could have raised, and it was willing to forego doing that if he went after the real bad guy in this case and was unable to collect. And the other one is the novelty of the legal issues. I agree that the basic case here isn't that complex, but what made it complex is that he didn't attach a copy of the depositor's agreement.
But that's something you have. Your client has this. R&J moved for summary judgment, made a prima facie showing. Your client has quite clear obligations. They want to avoid summary judgment. If you thought there was some defense under the contract, and I don't mean you personally, Mr. Silence, but Wells Fargo could have come forward with admissible evidence and saying, we have a defense. And instead, it raised a completely different argument. Not even the universe of what we're discussing.
Right, but that he didn't argue that there's an implied agreement in his motion for summary judgment, and he didn't attach the copy of the actual agreement, and that he filed his motion for summary judgment 2 days after the answer was filed. No discovery had been done, initial disclosures hadn't been done, and by doing that, it made things way more
But your client could have
complicated.
filed a Rule 56F affidavit and said it's premature. They didn't do that either.
That is true, but it is his burden, appellant's burden, to prove every element of his claim. We don't have to disprove it. I mean, he has to first say, here's the contract, here's the terms. And Wells Fargo took the position that, well, what contract? We don't dispute.
Wells Fargo, your client, the bank, despite Arizona law since 1942, took the position that there was no contract between R&J or with R&J based on this depositor?
No, we never denied that there was an agreement. Even in the response to the motion for summary judgment, that wasn't an issue we raised. What we argued was that he didn't attach the agreement that was breached. And by doing that, the trial court didn't know that the agreement said, the trial court still has no idea that the agreement says if you walk into a bank and the bank gives you money accidentally when it shouldn't have, but if there's good reason, it believed that the person was an agent, and in this case the bad guy was a 1% owner on the account and was the previous owner, so he had gone to the bank on multiple occasions, taken out money, and for those reasons, the bank said, okay, well, you're not a signatory, but it appears that you're an agent and you had the authority to withdraw, and let him do it. And Wells Fargo doesn't dispute that he shouldn't have gotten the money, but it disputes that there were circumstances that justified what it did.
You know, in talking about efforts at settlement, which is one of the Warner factors, talk to me a little bit about Mr. Ensign's argument that from his perception, Wells Fargo simply stonewalled and would not respond, would not communicate, and it wasn't until the comptroller of the currency complaint that any kind of quasi-response came out. And honestly, reading the record lends some support to his characterization in a way that is somewhat troublesome. So talk to me about that, why Wells Fargo didn't do something to try to get this nipped in the bud.
Wells Fargo's position was that it was early on. We filed a motion for summary judgment 2 days after the answer.
I'm talking about pre-litigation, though, when his client made attempts to communicate with the bank and get this resolved without having
I
to
see.
file
Yeah,
suit.
the bank wrote a letter. Some representative of the bank wrote a letter saying to him essentially what I said, which is that there was a mistaken belief that this person came into the account, he's a 1% owner, and the money was given to him, but we're not going to pay that claim because there were circumstances that justified what happened. And so that was the letter that was sent pre-litigation, post-litigation, right after we filed the complaint, and nothing else had occurred is when we made a written offer to pay the full $16,500 on the terms that Mr. Ensign described. And that was our offer throughout the case. It was made 3 times in writing, and that's where the case, and he said no, and filed his motion for summary judgment, and that's where things kind of snowballed into where we are now.
The thing you've got going for you is the standard of review. But, I think you can tell from the questions that probably at least 2 of us have expressed, and maybe a third, that we would not have ruled this way, that we would have awarded them fees. So talk to us about abuse of discretion and why you still win.
Well, you're right. There's cases, we could cite you a string side of 200 cases where the court affirmed in cases where maybe it thought the trial court got it wrong. But your place as the Court of Appeals is to review for a very limited abuse of discretion. And as you pointed out, even in cases where you think the trial court was wrong and none of the factors really favor the losing party, the Court of Appeals still affirms. And that's because it shouldn't be in the business of second guessing and essentially inserting its own opinions into what the trial court, who was there firsthand and saw everything, felt about the case.
This is about as close to an abuse of discretion as I can think of. Really, given Wells Fargo's conduct before the litigation and during the litigation, and this is a really close question. And, yes, we do review for abuse of discretion, but that, as Justice Feldman wrote in State v. Chappell, that doesn't mean that we're basically inert. And this is a real close call.
Well, again, I think 3 of the 6 factors favor Wells Fargo, even if just slightly. The settlement efforts, the defenses that were raised, and that this case became complicated because there was no discovery taken, no disclosures, and his complaint and his motion for summary judgment were really brief and just said Wells Fargo breached its agreement, it owes $16,000. The end, no legal cites, no supporting authority. And while maybe the trial court knew all this, and maybe it's an expert on banking law, but if it's not, these are arguments that the plaintiff has the burden to make and prove and convince the trial court. And here the trial court you have the transcript, expressed serious doubts about whether the signature card was really a contract on which it could grant summary judgment.
But we know, your client doesn't dispute that there was a contract, so it seems very odd to rely on various aspects of the lack of proof of a contract.
Yeah, we're in an odd spot. We're in a bit of an odd spot because we made a business decision not to appeal the trial court's decision on the breach of contract claim.
Good move.
We do.
That actually was a good move in light of Arizona case law. That there's a contract. It exists as a matter of law. If you had nothing, no piece of paper, no signature card, no nothing, Arizona law would have said that's a contract between the parties.
But the trial court, it struggled with this issue. It said, I don't know if the signature card is a contract. And I think it was incumbent upon him to explain what you just said. And it wasn't until his reply in support of his fee application that he came forward with the 1940s case law you're talking about, saying that you don't need a contract. There is an implied contract.
And Wells Fargo didn't know that its legal relationship with its depositor was a contract?
I wasn't there, Your Honor. I was just involved in the appeal, so quite frankly, I don't know the answer to that. I'm sure people in Wells Fargo are. Whether the attorneys handling the case at that time on our firm knew, I'm not 100% sure.
Can you just briefly state for me, to support the trial court's decision, that it has to be reasonable, so there has to be a reason that I don't quarrel that it needs to be stated on the record, but it needs to be in the record. Can you just briefly restate the three factors that you think?
Yeah, the first one is the merits of the party's defense. And
we're not too big a fan of.
Yeah, we're not.
Okay. And the other one is that Wells Fargo did offer to pay the full principal amount owed on terms, as Mr. Ensign described. And the third one is the novel legal issues. And I understand you think it's very straightforward that there's 1940s case law that says this is an implied agreement. But what complicated this is that, again, he in his haste, he filed a motion for summary judgment and didn't cite the law, didn't attach the agreement, and the trial court wasn't sure what agreement had been breached. All that was before the trial court was a signature card
How
and
does
no law.
uncertainty by a trial court and what is longstanding Arizona law make this a novel issue?
What I'm saying is novel is that he made arguments for the first time in his reply at his FIAP, arguing his case. He tried to come to Wells Fargo and say, hey, I want the depositors agreement after he got summary judgment, as opposed to
fair
before.
to R&J, Wells Fargo did not respond to the summary judgment motion by saying, we don't have an agreement. The motion at PDF page 3 says, it's submitted that the facts stated above show that Wells Fargo breached its agreement with R&J. Okay? And instead of taking that on and saying, we didn't breach because we acted in good faith, and presumably Wells Fargo knows its own business. It came up with another theory that made no sense whatsoever. So, again, I don't know what's novel about this. It seems to me at best you've got is the offer to settle as possibly a factor that's tipping in Wells Fargo's.
And general case law that says this court is very deferential to the trial court's decision, even if it feels it was not a good one.
That gets me back to the very first question I threw out at you, and I don't know that there's an answer, but it's the nub of what I'm struggling with is, yes, it's a very deferential standard, but we still have to have some confidence from the record that the court exercised its discretion. And again, I see rulings on fees that say, I considered the Warner factors and it's ordered blank. That's minimally adequate because at least it tells us the court knew to exercise its discretion and did. Do we have anything comparable to that in this record from Judge Cunanan that lets us know that, yes, he didn't just say a pox on both of you, no fees, and that he engaged in some principled exercise of discretion?
Well,
Any clue to that?
What I'm confident is he heard all of the arguments that you heard today. He saw all the evidence. He had a oral argument, both sides. You have the transcript of that.
Not on the fee request.
Yeah, I'm focusing on the fee issue, not the summary judgment. Anything that we can glean from the record that shows he knew what he should consider, did it, and therefore we should defer to him.
The Warner factors were briefed in his fee application and our response and his reply, and then he also filed a motion for a new trial where he tried to convince the trial court that it got it wrong. And we again engaged in a discussion of the Warner factors, and
So
I'm confident he was aware of all the information he needed.
So the parties argued over the Warner factors then?
Yes, I think he heard all the arguments. He was fully aware of the Warner factors. Mr. Ensign urged the trial court to put on the record what his reasons were, and he didn't, but he's not required to. And if a trial court doesn't put on their explanation and their judgment about why fees aren't being awarded, this court should affirm if there's any reasonable basis to do so, even if one of the 6 Warner factors even slightly favors us, or if none of them favor, as you pointed out when you started this court is still supposed to affirm. And briefly, as for the new trial, I mean, he could have discovered the account agreements by sending a discovery request or waiting for initial disclosures. And they were the template agreement was even online had he gone online. So I don't want to spend time talking about that, but he's not entitled to a new trial because he could have discovered this agreement that, and ironically, had he discovered the agreement, I think the trial court would have been even more inclined not to award fees because it talked about how Wells Fargo isn't liable to depositors if it gives out money based on a good faith belief that the person had authority to withdraw money. Thank you.
Thank you.
Thank you. And rebuttal, Mr. Insing?
Thank you. I need to correct a few things that the counsel said here. He said there was an oral argument on the motion for fees where Judge Cunanan heard all the arguments. No, there was not. We requested oral argument. He denied it. We requested oral argument on the motion for new trial. He denied it. So there was no oral argument on the motion for fees.
But what about the notion that the Warner factors were briefed extensively? I mean, I'm playing devil's advocate with my own question to Mr. Silence. I am troubled when we cannot discern that the court exercised its discretion by some even token language that it's done so. But on the other hand, the briefing did focus extensively on the Warner factors. So why shouldn't we defer and assume that he balanced those and maybe focused on the settlement issue and the amount in controversy?
Because everything that was in front of Judge Cunanan is in front of you. Yes, those Warner factors were discussed, but there's no, well, they try to say that they're favored by some of those factors, but they're not. All of those factors, each and every one, favors R and J. And the big one, the merits of the defense, they never had any merit to this case. No merit whatsoever to the defense. And the only thing they could raise is, well, your claim's not ripe yet. And there was no case law for that. But they make a motion to dismiss, then they make a motion to stay, and it's delay. And their one factor that they made an offer, which was simply to spend thousands of dollars pursuing somebody else, and then if you win, we'll pay you the principal amount, but that's it. No fees. That is no offer at all. And we submit, yes, Your Honor.
I'm sorry, forgive me.
That's all right.
Forgive me, I just don't remember the record well enough. Is there any evidence in this record that Wells Fargo made an oral offer to pays the $16,500 before your client filed the lawsuit?
Absolutely not. And that was another misstatement I wanted to correct. There was absolutely no oral offer made to do that. And that's just a misstatement. The offer in December of 2012, the case was filed in August, R&J made an offer to settle for $20,000, which was essentially the $17,500 in interest and costs and the $16,500 plus $2,500 in fees. That's what we made after making the motion for summary judgment. No response to that offer whatsoever. Again, we made an offer to settle. Well, just settle for the amount and let the court decide the issue of attorney's fees. No response whatsoever to that offer. Now, it's submitted that when somebody has no defense, when somebody does what Wells Fargo did, stonewall us, delay with the motion to dismiss, I mean, the complaint clearly stated causes of action, and then do a 4-sentence motion to stay with no authority as to why the court should stay this, their conduct was reprehensible in this case. And for them to make one offer that chase somebody and then we'll pay you the principal amount, we submit cannot be outweighed by these other factors here and by our settlement offers and by a defendant that had no legal defense ever. I mean, they had no justification for doing what they did. But all they did was say, go chase somebody. And it's submitted that that's one of the things was litigation could have been avoided? No. Were our efforts completely superfluous in achieving the result? No. Everything that we did was absolutely necessary, and we went to extraordinary lengths to try to get the depositor agreement, to try to get any kind of response out of Wells Fargo. And that's in the record. But Judge Cunanan, for some reason, said no fees, and we still don't know why. We asked him to explain it and explain that appellate courts like to see that, and he wouldn't do that, wouldn't grant us oral argument on anything. So we really don't know. But what we do submit is that there's nothing in the record that supports that decision. If you thought that the Wells Fargo offer should outweigh everything else, and then this is a reasonable basis for the judge's decision, well, then we lose. But we submit that that can't possibly be the case. The one offer that they made to Chase Pearson is just one of the factors involved. And with all due respect, it's no offer at all. My client would have lost money chasing Pearson to try to get a judgment, and it would make no economic sense to then come to Wells Fargo and say, okay, please pay us the $16,500. As it is now, my client has lost money to a defendant that never had any legal reason to do what it did. And
Well, to be fair, we've kind of railed about the bank, but it does have the statement in its depositor agreement that if it acts in good faith, it's not guilty of breach of contract. So, I mean, they didn't tee it up.
they never raised that.
Well, they
argument.
didn't raise it in a timely fashion. I think it's fair to say you don't raise a defense to a claim for breach of contract by trying to now avoid paying attorney's fees after the court has ruled on the merits. It's a little late in the game. Yeah.
Well, right. We submit that the only defense they ever raised was your claim isn't ripe, you had to go chase Pearson and get your judgment first, and that's just contrary to law. There was no law to support that. And we submit that there really is no evidence to support an exercise of discretion denying attorney's fees, and this court should reverse that. Thank you.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess in preparation for our next argument. Thank you.